States. Jonathan Turley is joining us with the breaking news that we just heard this judge is blocking the birthright citizenship executive order that came from the president in his first days of office. Jonathan, your reaction here?
Well, this is along the lines of what we just discussed on the air, that this is the most vulnerable executive order of all of those issued by President Trump. The widespread expectation was this result. The Trump administration knew that. There's every indication that the Trump administration invited a challenge because they want to get into the courts in order to eventually make it to the Supreme Court. The Supreme Court can, of course, change the interpretation of the 14th Amendment, although I would still say that that is unlikely. But I think that what you're really seeing playing out here is a dual legal and political strategy. Frankly, I think that the Trump administration views this as winning either way. That is, to the extent that it forces Democrats to oppose the legislation in Congress, to oppose this effort in court, it plays well with a large number of citizens who don't agree with birthright citizenship. People should realize that we're in the minority on this. Most of our close allies in Europe, most of the world, does not recognize birthright citizenship. So I think you're seeing both a legal and political strategy playing out.
So this was tested in the courts. It was a long time ago. It was back in 1898, the case of Wong Kim Ark, who was son of Chinese parents. He was born in San Francisco. Under the 14th Amendment, he would have qualified under the original interpretation as a citizen of the United States. He went to visit his parents in China. Then when he came back, he was denied entry. But the Supreme Court decided in favor of him. So that's, I guess, since then, it's been determined that anybody who is in this country who's not working as a diplomatic attaché or something like that, or working diplomatically for an embassy, if they have a child in the United States, that child is an American citizen. But getting back to your point, when you look at that affirmation of the 14th Amendment provision in 1898 and this idea that, well, maybe they don't need a constitutional amendment, can the Supreme Court simply clarify what they believe is the intention of the 14th Amendment, Jonathan?
Yes, they can. I mean, the thing is, the case that you mentioned, people who challenge birthright citizenship point out that the Chinese parents were lawfully here. No one is challenging the idea that the children of citizens or lawful residents can have this claim. But yes, the Supreme Court can adopt an alternative interpretation of those 6 key words. What do they mean? And there may be some justices who are inclined to do that. But this has been the longstanding precedent that the Supreme Court has followed. So it was virtually impossible that the Trump administration could prevail in the lower courts because they would feel bound by this case law. Now, the question about head counting on the Supreme Court makes this rather difficult. I think that there might be some justices who are interested in re-examining those 6 words and what they mean and not effectively reading them out of the amendment. But I also think that what these justices are going to be really influenced by is that there was a division of opinion at the time this was passed. Some of the people at that time said that it did not allow birthright citizenship, while others said that it did. And I think that you might find some conservative justices inclined to stay with that approach. Justices like John Roberts, who tends to be an incrementalist, tends to be much more conservative on these types of questions.
All right, Professor, stand by with us if you would.
We have more breaking news to kick off this hour of The Will Cain Show. This afternoon, a federal judge temporarily blocking President Trump's executive order on birthright citizenship, calling it blatantly unconstitutional. Those leading the challenge against the order say more than 150,000 newborn children would be denied citizenship every year if this order stands. President Trump saying the battle isn't over yet.
Mr. President, a U.S. judge temporarily blocks the birthright citizenship order. Do you have any reaction?
No, obviously we'll appeal it. They put it before a certain judge in Seattle, I guess, right? And there's no surprises with that judge.
There's a lot of hysteria around the birthright citizenship executive order, but the idea behind President Trump's order is nothing new, at least around the world. Allow me to explain. Some context might help put in perspective the hysteria. First, number one, birthright citizenship is not the norm around the world. Only about 30 countries, mostly in the Western Hemisphere, recognize the idea that if you're born on their soil, you have as your birthright citizenship. No, instead, most of the world, Europe, Asia, Africa, work like Australia. This is how it works in Australia. In Australia, if a child is born to a permanent resident or a citizen of one of the parents of that child of Australia, then they are a citizen. Or in an alternative, if that child resides in Australia for a decade after birth, they can apply for citizenship. Now, as I mentioned, very few countries around the world recognize birthright citizenship, and some that previously have repealed the concept. I'll give you Dominican Republic and Ireland. Ireland in 2004 became the last European country to recognize birthright citizenship. They repealed that measure in 2004 with a 79% referendum. The Dominican Republic repealed birthright citizenship in 2013 as they were flooded with illegal immigrants from Haiti, some 200,000 children from Haiti born in the DR. Those numbers reflect some of the numbers we're now being told would be the number of children born here that would not have citizenship if we repeal birthright citizenship. Now, let's go to some background on the Supreme Court case that helped establish the concept of birthright citizenship. It goes back to 1898. The case was the U.S. versus Wong Kim Ark. Wong Kim Ark was a 21-year-old Chinese immigrant who was born here in the United States. He left at the age of 21 to go visit relatives in China. When he came back to the United States, he was denied re-entry. The Supreme Court eventually heard the case of Wong Kim Ark, and the question was, what does the language of the 14th Amendment mean for birthright citizenship? I want to, if I may, read for you the language of the 14th Amendment. It reads simply and as follows: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. But the key phrase for legal scholars that want to see this fight go to the Supreme Court is what is meant by subject to the jurisdiction thereof. If someone is born to parents of another country, are they not subject to the jurisdiction of, say, Mexico? Carrie, great to have you right now. Let's start with the strategy behind the executive order and now this federal judge that has said that the executive order doing away with birthright citizenship is blatantly unconstitutional. Is this setting us up for a fight at the Supreme Court?
Yeah, I certainly think so. Now, of course, we know the Supreme Court doesn't have to take it up if it eventually makes its way there, but that seems to be the strategy. And I think it's a good one because this is a fascinating legal question that, Will, has been debated, as you are pointing out, I mean, for a very long time now. Scholars on both sides of the aisles have been debating the meaning of that clause that you just laid out. And the judge, in his issuing and signing this TRO today, when he said something like, "I've never heard such an argument made," and I thought to myself, well, how can you say that? Have you not been reading the debates that have gone on around this for so long, including from the retired Seventh Circuit Judge Richard Posner, who he thought this was unconstitutional. And it happened to be a former colleague of mine from DOJ, Brett Shumate, who's a very good constitutional law attorney who's arguing that case. So they'll go and argue the merits of this in just a couple of weeks from now. But it's certainly a very interesting question.
We should inform the audience, as we started to right there, that this has been somewhat settled precedent since 1898, that the Supreme Court has read the concept of birthright citizenship to mean born on this soil. Now, the current Supreme Court is full of justices who could be described as originalists. That means they look back to the original interpretation or intention of the people that framed the Constitution. The 14th Amendment, that would be in the 1800s. Do you think, therefore, that the Supreme Court justices would actually go back and uphold the idea that if you're born here on this soil, you have birthright?
Well, they would certainly go back to the intent behind the 14th Amendment. And the intent behind it was very clear. It was to undo the grave harm that occurred because of the terrible Supreme Court Dred Scott decision, which said that African Americans, Africans who had been here for hundreds of years, enslaved people, were not citizens. And so that amendment was enacted directly to undo that wrong. And, you know, Will, what I don't think most people know is there was a senator from Michigan who wrote the clause, that phrase, subject to the jurisdiction thereof. He specifically gave speeches at the time that said that means it excludes aliens. So that was the understanding for many years until the Supreme Court handed down their decision in 1898, the case you were just talking about. Right. And even there, when they interpreted it a different way, they did emphasize that the parents of that Chinese national had been, quote, permanently domiciled in the United States for a very long time. And if you remember the history around that time, the context, it was almost impossible for Chinese nationals to even become citizens. Right. So the facts, the times, the zeitgeist, it was very different than, say, now when people are using it as a technical loophole to, you know, embark on birth tourism.
Right. I'm glad you pointed out the 14th Amendment was couched in doing away with that terrible Dred Scott decision. Of course, the African slaves here in the United States weren't subject to any other jurisdiction giving them citizenship. But just to put some color on what you had to say, Senator Jacob Howard, who helped draft that amendment, the 14th Amendment, said, this will not, of course, include persons born in the United States who are foreigners or aliens or belong to the subject of another jurisdiction. That seems original intent. This seems to be a fascinating fight, potentially, at the Supreme Court. Carrie Bond, thank you so much for being with us.
Thank you.
Tonight, the White House, Congress, the courts, and immigration advocates are gearing up for a fight over President Trump's desire to redefine birthright citizenship. It would be a long and complicated process. Correspondent David Spunt shows us this evening.
This is step one. We have a long way to go. A federal judge in Seattle handing President Trump the first court loss of his second presidency, swiftly blocking an executive order that would redefine birthright citizenship. Inside a packed courtroom, Reagan-appointed Judge John Kuhnauer called the president's order blatantly unconstitutional. 22 states are suing in two separate lawsuits. Trump's order would end the practice of giving citizenship to a child born in the United States, even if both parents are not citizens.
You are an American if you were born in the United States.
This restraining order sets the administration on a likely path to the Supreme Court. House Republicans introducing a bill to end birthright citizenship as we know it.
This is about ensuring the citizenship, a cornerstone of our national identity. It is protected, respected, and aligned with the principles upon which this country was built.
Even if that became law, that's not enough. Birthright citizenship is specifically mentioned in the Constitution's 14th Amendment, adopted in 1868. It reads in part, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The DOJ is focused on 6 words, and subject to the jurisdiction thereof. And a spokesperson there tells Fox News, we look forward to presenting a full merits argument to the court and to the American people who are desperate to see our nation's laws enforced. Brett, if this should make it to the U.S. Supreme Court, which is certainly possible, and the Supreme Court rules against the administration, then there's talk about changing the 14th Amendment or changing the Constitution, but that's a complicated process. That takes 2/3 of each chamber, the House and the Senate, and 3/4 of all state legislatures to change the Constitution. So we're in this, as you mentioned in the intro, for many months, if not longer. Brett?
David Spunt at the Justice Department. David, thanks.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.